Hello, I'm Stephen Fox. I'm a bankruptcy attorney. I represent businesses that look to reorganize through Chapter 11 business reorganization, and I represent creditors looking to protect their interests in Chapter 11 bankruptcy. Although my office is in California, for many years I have represented both business debtors and creditors throughout the United States, and I only recommend bankruptcy when it is the best option. I have this prejudice. I believe that Chapter 11 business reorganization is one of the greatest inventions that this country has ever created. Think about it. A company fails, or it's in severe distress, and it gets an opportunity. It gets a safe harbor in Chapter 11. It gets to try out things and see how the company can work better, how it can work right. It gets a chance to grow, to thrive, to propose a plan of reorganization, and to pay creditors what it can pay over a period of years at a rate in an amount that the company can afford. There's no other bankruptcy system on this planet that is as good as our system, our Chapter 11 business reorganization. I want to talk to you today about the consequences of choosing the wrong attorney for your company's Chapter 11. Remember, there are a lot of attorneys out there. However, most attorneys know very little about bankruptcy. Bankruptcy is a niche. And then within the niche of bankruptcy is Chapter 11 reorganization. There are very few bankruptcy lawyers who are skilled in both the legal aspects of Chapter 11 and the business aspects of Chapter 11, how to help you diagnose the problems, how to fix them, and how to help keep them fixed. These are difficult issues, and there are very, very few attorneys who do this kind of work. Today's story is about a failed company, and it's a tragic story because it didn't have to happen. This was an all-American company. The owner, good guy. He had a dream, he had a vision, and he came up with a business that is in big demand, or I should say, was in big demand. And it would be in demand for years to come. He had over 100 employees. He had many millions of dollars of machinery and equipment. He had a lot of vehicles. He had a great business. There were also financial problems, management problems, there were operational problems, and he understood the company needed a bankruptcy. My client was one of the junior secured creditors, secured by all these different assets. So what happens? Knowing that he needs a bankruptcy, what does he do? He goes to an attorney and asks if the attorney is qualified. The attorney is a young guy. The attorney wants to learn how to do Chapter 11. The attorney has no experience on the legal side of Chapter 11 and no experience on the business side of Chapter 11. But he says, I'll take the job, and he quotes a fairly low retainer. The owner of the company thinks, great, I've got someone who's qualified. I got the money, gave him the money. Let's do the Chapter 11. I get a phone call about 2 weeks after the bankruptcy is filed. My client, the junior creditor, the junior lender, wants me involved in the case and says, there are some really serious problems there, and we have a lot of money in the case. Go and protect our interests. So that's what I do. 3 weeks into the case, I'm now involved in the case, and there are no major motions filed. And these motions are called first-day motions. First-day motions are a wonderful thing. They involve requesting permission to use the monies. It's called cash collateral. Paying payroll, taking care of utilities, dealing with critical vendors, dealing with all sorts of problems. And one of the best parts of first-day motions is the debtor gets to be there first with filings with the court, tells the court what the story is. The debtor gets to set the narrative or set the table before the creditors come in and say all the terrible things about the debtor. The debtor gets to go in there first. We're now 3 weeks into the case, and the debtor's silent. That is a horrible mistake, and it happened in this case. So, 3 weeks in, the debtor's attorney files his first motion, a motion to use money, to use cash collateral. The motion is a joke. The financial reports look silly, and everyone knows it. And the projection, the required projection of future monies coming in, future cost of goods sold, future expenses all through this period of maybe 8 to 10 weeks. It's all nonsense. Everyone, including the judge, can see that from the very beginning. So what happens? The first hearing is called a couple days after the papers are filed. Like other creditor attorneys, I fly in, we go to the courthouse, we're there in the courtroom, everyone's there except for the debtor's attorney. The debtor's attorney was there by telephone. He had no clue that this was a crucial hearing. So what did he do? He phoned it in. At the hearing, the judge didn't want to grant the motion. He was ready to shut down the company because the motion was deficient. And he even laid out why the motion was deficient. And at one point he said, "Mr. Fox, don't you want to have this done?" And I said, "Your Honor, I really do. My client does. But I've talked with my client, and for at least for today, I'm holding our powder. We're not going to shoot off our gun. You need to grant the motion." And the other lender's attorney said the same thing. Afterwards, I call up the debtor's attorney, and I talk with him, and I say, "My client has told me it's okay to discuss this with you. Here are some of the things you need to do. And my client's okay because we need your company to succeed. We want your company to succeed, and we want to get paid. We don't want it to go down." So I told him a number of steps to do. He doesn't do any of them. It turns out two other lenders' attorneys also called up the debtor's attorney and told him what to do. He didn't do any of it. He was not competent. Come to about the 90th day of the case, and what happens? The judge said, "I've had it. Case over. Shut down. Consequence, over 100 employees are now fired. All the machinery equipment are gone. The vehicles are gone. A great company is no more." And it was because the owner chose badly. And I can't blame the owner a lot. I can blame him somewhat. But it's very hard to know who is a good attorney and who isn't. Here are some questions that you should automatically ask if you are in the business of looking for a Chapter 11 business attorney to represent your client. First question, have you done this before? If you have, how often? How many of your Chapter 11s have been businesses? How many have really been cases about lawsuits or litigation? When you reorganize a business, what does that mean to you? Keep it an open-ended question. What does it mean to you? And then follow up. Do you handle the legal aspects of the Chapter 11? What business aspects of a Chapter 11 do you handle? And again, notice I'm keeping it open. What business aspects do you handle? You want the attorney to tell you what the attorney does. Because I'll tell you now, a lot of Chapter 11 attorneys, if you ask them what they will handle, they'll tell you the legal side. And if you ask them what business aspects they handle, they will tell you one or two things, and that's about it. The reality is that you have a team that includes the bankruptcy lawyer. It includes the CPA. It includes you and a number of other people. And everyone has to work on the reorganization. What other questions? What information do you want me, the owner of the company, to bring to the consultation? And you want to bring, as the owner of the company, a lot of financial information. You want to bring tax returns. You want to bring all sorts of paper with you, because whatever advice the attorney gives you is only as good as the information the attorney has in front of him or her. So if the attorney says, just come on in and let's talk, that tells you that not only are you getting a sales talk, whatever advice you're going to get is useless. So it's not worth going to the consultation. You want a consultation that's going to take an hour or more, and you expect to pay for that consultation. If you want real legal advice, you have to put in some real money. You need to show some commitment. Final question, and this is a tough one. You ask this of the attorney if you go in for a consultation and you think the attorney may be a good fit for you and for your company. Say, will you let me talk to some of your current or former clients so I can ask them about how you handled their business reorganizations? Questions you can ask the former clients include, was the charge fair? Did the lawyer work hard? Did the lawyer have good integrity? Did the lawyer communicate well? These are all important questions because this is a team effort. And if the attorney is not well qualified, then the team and the company and the reorganization are all going to be badly hurt. Most attorneys that do Chapter 11 reorganization believe that a successful Chapter 11 is when a plan is approved by the judge. That's nonsense. A successful Chapter 11 is when a broken company gets fixed and can pay its creditors. The approved plan is a necessary part of it. I believe that if you have a plan that the judge approves, but you have a broken company, what you really have is a broken company and a broken plan. I have over 30 years' experience representing business debtors across the United States and representing creditors in Chapter 11 all across the United States. If you think for any reason that your company may be on the road to bankruptcy, pick up the phone and call me. Let's talk. Email me. Do something. Take care.